Hi, my name is Derek Fahey. I am a registered patent attorney and trademark attorney with the Plus IP firm, and this is going to be a brief video on how to protect your artwork or your works on social media channels and how you can actually use other people's work on social media channels. And first off, again, my name is Derek Fahey. I'm an intellectual property attorney. I'm licensed to practice law before the United States Patent and Trademark Office. We help people protect their intellectual property with copyrights, patents, and trademarks. And we also deal with enforcement issues. So if you have someone copy your work, we can help you with that. So first off, let's talk about social media. Just because you actually see somebody else's photo on social media doesn't mean that you can download that photo, copy it, post it online, and then give the author credit and think you're not copying their work. That's actually copying. What you should be doing is, if you are copying, if you want to use somebody's photo that you saw on Instagram, you should ask permission to actually use their photo. You can message them and say, this is your photo, I would like to use it. Do I have permission to use it? And if they do, great, you can post it. If they do not, don't use it, because that's how you can walk into a lawsuit. I've seen it happen a lot. Just be really careful with social media. Now, sometimes on social media, like for example on TikTok, you can actually repost the actual content. For example, if you like someone's video and you want to make a comment about the video, the TikTok terms and conditions allow you to do that. But if you were to download it, take the video and post it on somebody else's social media platform or post it on your YouTube channel, you wouldn't actually be allowed to actually do that, be considered copying. Okay, so that's just briefly some social media stuff. But let's talk about if you're an actual creator. How can you protect yourself? Well, in the US, you can actually file a single application for up to 750 photographs to register those particular works. Now, there's a caveat. It has to be the same author. If you're a photographer, you'd be considered the author, and it has to be within the same calendar year, and they all have to be either published or unpublished. So you need to make sure before you actually post your photos online, if you do want to register them, you can actually register up to 750 photographs at the same time. So you'd actually save application fees. And why is it important? You're a photographer, you make your money on selling your photographs. What you want to do is actually register those so that if you ever have to enforce it and tell somebody to take it off their website or some other social media channel, you'd be able to do that and with confidence know that you'd be able to get it down. And then why do I say that? Well, in the US, in order to bring a copyright infringement lawsuit, you actually have to register your work. So to register that, you have to actually file an application with the Copyright Office, which we can certainly help you with. But you have to register the works. So even if you found somebody using your photo, you couldn't even bring a lawsuit, even if you wanted to, until you register it. So it's better to register early. Another reason why it's better to register early is because in order to get statutory damages, which I'll explain what that means in a second, and attorney's fees and costs for having to bring the lawsuit, you actually must do so within a certain period of time. So first off, statutory damages. Why is that so important? In the US, you can actually, you don't have to prove damages. Typically in a lawsuit, you have to show lost profits, a reasonable royalty, or some other way to actually calculate damages. Statutory damages basically say, if somebody else copies your work and without your permission, and it's your work and you can prove that, you're able to automatically get a certain amount of damages, which is great because you don't have to show that you have lost profits in some sort of fashion. That's really good news. And in the US, you can actually, it's between $750 up to $30,000 if it wasn't willful. If it's willful copying, you could actually get up to $150,000 per infringement. So that's a very big benefit to have statutory damages. And also attorney's fees and costs. What does that mean? If you have to bring a lawsuit against somebody, the other person, if you were to win the lawsuit, would have to pay your attorney's fees and costs to do that. But the attorney's fees and costs and also statutory damages are only applicable if you register within a certain period of time. So when is that time, you may be asking? Well, you have to register it, according to the statute, within 3 months of your first publication, or within 1 month of finding out that somebody else is infringing. So if you find out that somebody else is infringing on your works, you can actually then file a registered copyright, but it has to be done within 1 month. So it's really critical to register earlier rather than later. You can wait until you get infringed on, but it may be more difficult, it may be more costly to do that because you may have to pay rush fees, etc. So it's really important to register your copyrights early. It provides an exceptional benefit to you, and it's also a requirement actually to have a registered copyright to bring a lawsuit. Now, why is attorney's fees and costs so important? Well, attorney's fees and costs are so important because if you're trying to get somebody to bring a lawsuit for you, it's a huge benefit to that attorney to be able to recover their attorney's fees and costs. So it's going to be easier for you to hire an attorney on a contingency fee basis if that attorney is able to get their attorney's fees and costs for the particular matter. So think about registering your copyrights or your works early. Now, so photographs, we talked about 750 photographs. That's actually a great benefit. So you can take 750 photographs, register them all in 1 year, and then you can actually start selling the works and potentially getting licensing fees from people that you sell them to. And also, if you find somebody using your work online, you can actually get them to take it down and also get them to pay you money for a reasonable royalty for using the works. Super important. But there's also another way you can register group works. For example, if it's an audio-video work, you can still register up to 10 works. So you can actually register up to 10 works, but they must be all unpublished. So it's really important to talk with an attorney before you actually start putting that work out. Why is that important? Many times people are doing videos and learning different learning platforms that have particular content that they use, and they want to protect that, whether it's a workbook or whether it's some sort of instruction manual. You can actually protect that with copyright law. So it's really important to speak with a copyright attorney to know if you can actually qualify for these group registrations. It's less costly, it saves you money. In the long term, it will actually be better for you and be more beneficial for your business. So think about those things when you're publishing your works. And if you have any questions, you can give us a call. My name is Derek Fahey. Our website is www.plusfirm.com. We handle all types of copyright matters and other intellectual property matters. You can also find me on Instagram, Derek Fahey, P-A, DEREK-FAHEYPA. If you have any questions, leave us a comment and we'll answer it as soon as we can. Thanks a lot for watching and have a great day.